Okay, first thing I'm going to go over is because we didn't go over this last week, we went over the order but not the affidavit. This is very revealing of what's going on with these mortgages. In order for the mortgage to be he talks about this, and this guy is an attorney, this Thomas J. Adams. And he's testifying as an expert witness on behalf of LaSalle Bank National.
Let me go get my copy. I'll be right back.
Evidence and what's going on with this case, because this case is going to affect all the mortgages in this country, because none of these lenders or trust companies are transferring the assets to the trust fund to qualify as a REMIC or a real estate investment trust. So that means that the loan is in default at closing and the loan is unsecured. And he says that in this affidavit. This guy is testifying as an expert witness on behalf of the LaSalle National Bank. And this case was decided March 30th, 2011 of this year. And he's telling you in the order that the Phyllis Horace, who's the plaintiff, is the borrower in this case. And she's a third-party beneficiary because it was her proceeds from the note that funded the pooling and servicing agreement, part of the funds. So she has a preemptory claim. Beneficiary means that she has a title and ownership interest in the proceeds that are in this trust fund. And LaSalle Bank National Association is the trustee for the certificate holders of Bear Stearns Asset-Backed Securities 1 LLC. Well, none of these asset-backed securities are backed by anything. When I say they're not backed, I mean they're not secured by the mortgage loan, which is the deed of trust, because it was never transferred to the trust, which is the asset-backed securities trust. Neither the deed of trust or the note were transferred at closing to this trust. So the loan is, for all intents and purposes, is unsecured. It's not only unsecured, it's in default. The loan was in default at closing. That's why they're foreclosing on all these people, because they want to collect the tax. They're billing you for the tax. Because they never transferred the assets to the trust, they don't qualify as a real estate investment trust. So they don't get the tax exclusion that's provided for in Section 856 of Title 26. And we went over that last week. In order to qualify as a real estate investment trust, they have to transfer the funds at closing. And also they have to, under Title 15, Section 1641, when they amended Public Law 111-203, which is 15 U.S.C. 1640, which says that you have a claim and a defense and recoupment and set-off. Well, when they amended that in July 21st, 2010, they also amended Section 1641 of the Truth in Lending, which is Section 129 and 130. And what they did is, if there's a transfer done, they have to notify you within 30 days. The new owner does. He has to notify you in writing that he's the new signee and the owner of the loan documents. But they never do this. That's because they never transferred the funds in the first place. So if they didn't transfer the funds, the loan is in default and the loan is unsecured. If it's unsecured, that means there is no mortgage, because the deed of trust is the mortgage and the note is the obligation attached to the mortgage. So if the trust fund has neither the mortgage or the
breaking up,
obligation
Gene.
attached to the
Check
mortgage.
your connection. You're breaking up.
Okay. How am I now?
That's better.
Is that better?
Yeah, it's better. You were breaking up. So that's why when they have these real estate investment trusts, on
They
the
call them
91st
REMICs.
when they fail to qualify, the trust dissolves itself on the 91st day.
Yes, and it dissolves itself because there's no corpus inside the trust to sustain the trust. The trust
Correct.
collapses.
Right.
So they don't have any legal authority to be foreclosing on anybody.
You're still breaking up, Gene.
Let me pull these. Let me replug this back in.
We have a thing on the board that says you have an echo. I'm not hearing any echo on my side.
Okay, can you hear me now?
Yes, you're coming in loud and clear.
Okay, so what they're let me show you what I'm going to put. Well, let me finish this affidavit, then I'll show you the code sections that apply
Do
to
you want me to start reading?
Yeah, read this affidavit.
Okay. Let me briefly summarize my expertise and experience for the court. I began my career as an associate at Thatcher, Prophet & Wood in New York City, working on mortgage securitizations in 1989. In this position, I was one of the lawyers who worked on the very first vintage of pooling and servicing agreements, which dealt with the 1986 amendments to the IRS tax code, creating the REMIC structures. REMIC, Real Estate Mortgage Investment Corporation, right, Gene?
Which paragraph are you reading?
Page 2, top line. REMIC. What does REMIC stand for?
Real Estate Mortgage Investment Conduit. That's a
Conduit.
real estate investment
Real
trust.
estate. Okay,
That's
real
what
estate,
a real estate investment
mortgage
trust is.
investment conduit, which is the trust. My career
five
progressed
different-
from Thatcher, Prophet. Go ahead.
There's 5 different types of real estate investment trust. There's REMICs, FASTs. FASTs are Financial Asset Security Investment Trust. There's hybrid, what they call hybrid REITs. REITs is R-E-I-T, means Real Estate Investment Trust. You have an SPV. An SPV is a special purpose vehicle. A special purpose vehicle is a trust fund. They're called special purpose vehicles, and most of them are registered in Delaware as corporations, as a trust. An SPE is a special purpose entity. That's a company or a corporation. It can either be a company or a corporation. Then you have a BRE, which is a bankruptcy remote entity.
Bankruptcy what? Wait, bankruptcy,
entity.
you broke up. Wait, Dean, bankruptcy.
They're called BREs, bankrupt remote entities.
Bankrupt remote entities. Okay, go ahead.
What they use them for is they use them to protect third-party debtors.
Okay. All right, now I'll
Those-
continue. My career progressed from Thatcher, Profit, and Wood through a series of industry positions which all dealt with various aspects of mortgage loan securitization as set out in my curriculum vitae. I am familiar with the industry standards, customs, practices, and legal requirements of mortgage loan securitizations. I am also familiar with the law governing the creation, powers, authorities, and limitations of the securitization trust and their counterparties, including the trustees and servicers for the securitization trust. I have been retained by the plaintiff in this matter to review the documents presented to the court and to opine as to whether the trust in this action is in fact the owner of the promissory note secured by a mortgage upon which the plaintiff has foreclosed and claimed ownership. In formulating my opinion, I have reviewed the collateral file produced by the defendants and the securitization documents, including the trust agreement for the trust. The trust agreement which created the trust, that is the defendant in this action, is called a pooling and servicing agreement and is filed under oath with the Securities and Exchange Commission and is available online through the EDGAR website at sec.gov. The trust agreement for the securitization is filed as Exhibit 4.1 to Form 8-K with the SEC. I understand these documents are part of the court record. I am familiar with the industry standards, customs, and practices which existed at the time of this securitization and continue in force through the date of this affidavit. I have personal knowledge of these standards as a result of my employment training, education, and experience as sent out in my curriculum vitae. Section 11.03 of the PSA, page 133 of 397, is an election by the parties to the trust that the trust will be governed under the laws of the state of New York. What's a PSA, Gene?
Pooling and servicing agreement.
Okay. This court...
They just abbreviate that.
Well, yeah, but the people...
That's an abbreviation.
The people that are listening will want it defined.
It means pooling and servicing agreement.
Okay, PSA is pooling and servicing agreement. This court would be required to consider the impact of the action of any party to the trust agreement which violated the trust agreement under New York law. The trust agreement, here it is, known as PSA, sets forth how the trust acquires its assets. The trust agreement sets forth both powers and the limits of the powers of the trust. The PSA and the mortgage loan purchase agreement, when read together, require that each party to the side of sale of the mortgage loans endorse each promissory note to the next party in the chain of title until the promissory note is endorsed to the trustee for the benefit of the trust. This requirement is included in Exhibit L of the EMC purchase agreement found in Section 6A. In the PSA, this requirement is found at Section 2.01 on page 56-397. According to the requirements set forth in the trust agreement, I would expect to see a series of endorsements of the promissory note, reflective of each party who had an ownership interest in the promissory note, culminating with a blank endorsement from the depositor at the very minimum. The industry standards, customs, and practices would have been Nevertheless, this chain of endorsements is in order to comply with this PSA would have had to complete on or before the closing date of this deal, but in no event more than 90 days from the close date pursuant to Section 2.02A on page 58 of 397. The close date of this deal was February 28th. Excuse me, I unplugged my phone. Excuse me, I'm going to unplug my phone. Apologize. Okay, Closing date of this deal was 2006 on page 20 of 397. This has been the absence of these in the promissory note. In reviewing the file for this, I note there is no evidence of transfer. Any assignments which would have been necessary to transfer the mortgage to the trust would have been required to be made trust clear, or there is no evidence of transfer in the parties to the securitized conveyance of this trust has ownership. And the file offered by the defendant trust clearly demonstrates that this loan is not just
Your voice is breaking up.
Now,
Your voice is breaking up. Breaking up.
Your voice is breaking up.
I heard you, Gene. I'm trying to see if I actually have to plug in my phone here. Would you explain some of that I've just been reading?
Okay, you're on page 3, right?
I'm so upset. I don't know what to do about this phone ringing. Can you hear me clearly now?
I can hear you now, but you were breaking up when you were reading.
Okay, let's go
Your voice
back.
is breaking up.
I'll go back.
You got to tell me which paragraph you're reading so I know where you are. What number?
14. The evidence in the collateral file shows an utter and complete failure of the parties to this securitization to convey this promissory note to this trust. The defendant trust has offered no proof of ownership, and the collateral file offered by the defendant trust clearly demonstrates that this loan was not securitized, nor was it transferred to this trust. The court should also be aware that Section 9.12G set forth further explicit restrictions on the powers of the trustee and prohibits the trustee from taking any action which would jeopardize the REMIC status of the trust. These types of limitations are common and are present in this or a similar form in every pooling and servicing agreement which seeks to create a securitized trust that can claim the tax benefits of REMIC status under the U.S. Tax Code. Paragraph 16. Based upon the information provided to me and the documents that I've reviewed, I can state that the Horace promissory note has never been transferred to the defendant trust as required by the PSA on or before February 29, 2006. 17. Further, any attempt to accept a transfer of the Horace promissory note now would violate the REMIC provisions of the IRS tax code for a number of reasons. First, the loan is in default at this time. Therefore, the loan cannot be qualified mortgage loan under the IRS tax code because a qualified mortgage loan is a performing mortgage loan. Second, an attempted transfer to the trust is now after the closing date and the certificates were issued. In effect, the plaintiff would be claiming to have transferred an asset to a trust that has, by its own terms, been closed for more than 4 years at the time of the alleged transfer took place. Third, the promissory note was not endorsed to the trust by the depositor and is devoid of the required chain of endorsements required in the PSA, and which any reasonable market participant would expect to be present for the purposes of establish the series of true sales set forth in the PSA, to establish the chain of title on the promissory note for the purposes of bankruptcy remoteness. The claim that the Horace note has been transferred to the trust when it is endorsed in blank simply flies in the face of the mandatory terms of the PSA and is an extreme deviation from the industry standards, customs, and practices which prevailed at all time material to this transaction and which prevail today. Based upon my knowledge of the terms of this transaction, as well as my review of the documents presented to the court, as the evidence that this defendant trust owns the promissory note executed by Phyllis Horace is, in my opinion, that this trust does not own this promissory note. My opinion is based upon the evidence and the attorneys for this trust have provided to plaintiff's counsel and my personal knowledge of the requirements that were applicable to this securitization through the terms of the PSA, which is before the court, the industry standards, customs, practices applicable to residential mortgage-backed securities, the pleadings that are before the court, and the contents of the collateral file, which includes the promissory note and the mortgage. I make this affidavit on personal knowledge.
Okay, the reason that this was never transferred is spelled out, and I'm going to pull this up. Is because they don't own the security. See, it's not a note, it's a security. And nobody's bringing that out. That's why it's not being transferred, is because it's a security and they don't own it. That's because it was an investment contract, not a mortgage loan. Everybody's overlooking that fact, that it's not a mortgage loan.
Okay, we have a question on the board while you're getting that. Do credit card apps go into a REMIC too?
Yes. They do the same thing on a credit card that they do on a mortgage loan. There is no difference. It's the same process. They sell the DTC is the is the owner of both sides of the account, and they sell the cash flow claims to the beneficial interest holders, which are they're called beneficiaries, just like you're the beneficiary of the pooling and servicing agreement. All these mortgage payments, you're entitled. That's why they give you a recoupment and set-off. It's because your mortgage payments are funding the pooling and servicing agreement, which is part of the investment contract. You're an investor. You got to quit thinking of yourself as a debtor and a borrower, and look at it that you're an investor. Now, what is that? Can you see my screen?
I see it. I'm reading these questions. There was a lot of garbling and a lot of breaking up from you and me, but I think that's taken care of now. So okay. I hope it is. What I was reading, folks, you have a hard copy of that affidavit in your webinars and in your screenshots that were provided this week.
Okay, read what an adverse claim is. This is the reason that they don't own the security. Read that.
Adverse claim means a claim that a claimant has a property interest in a financial asset, and that it is a violation of the rights of the claimant for another person to hold, transfer, or deal with the financial asset.
Now, does that explain why they're not transferring these securities to the trust?
Well, that's because they don't own them, and they know they don't own them, and they know that it's a violation if they try to say they do own them.
Yes. So the security is a financial. What is a financial asset?
That's the note security, right?
Okay, read what a financial asset is. This is 8-102, subsection 9. Read that.
Financial asset, a security, an obligation of a person or a share, participation, or other interest in a person or in property or an enterprise of a person, which is or is of a type dealt in or traded on financial markets, or which is recognized in any area in which it is issued or dealt in as a medium for investment, or any property that is held by a securities intermediary for another person in a securities account if the securities intermediary has expressly agreed with the other person that the property is to be treated as a financial asset under this article. As context requires, the term means either the interest itself or the means by which a person's claim to it is evidenced, including a certificated or uncertificated security, a security certificate, or a security entitlement.
Okay, now read what security entitlement is. This is A-102, subsection 17.
Okay,
Article 8.
security entitlement means the rights and property interest of an entitlement holder with respect to a financial asset specified in Part 5.
Okay, so a security is a financial asset, and you have a property interest and a possessionary right not only in the instrument itself but in the proceeds. It says that in 3-306.
Okay.
Because the security is a negotiable instrument, it comes under Article 3. But because it's the security, it's governed by Article 8. That's why I'm reading this out of Article 8 so that you'll understand that.
So this is really any kind of a credit application or any kind of a loan application or anything like that. They're all a REMIC?
That's right. They're all real estate. You read that letter that I wrote to that judge. That judge
Yeah.
took the case off the calendar, and they dismissed. Both those cases are gone.
Okay.
You can do the same thing. A car loan is identical to a mortgage loan. It doesn't make any difference whether it's an automobile or real property. Doesn't make any difference. They're both handled the same way. They both have a B5 prospectus. A
Okay.
B5 prospectus is a B5 prospectus, whether it's an automobile or a house.
Okay, let me jump in here for just a minute. We have some notes here that some people didn't get those screenshots. It's only the people, I believe that was on the 326 call, that got that package. So email me privately and we'll get the payment for that and get it right out to you. All right, go ahead, Gene. So that means that every time you go out and use credit for anything, they all have their own PSAs. They all have their requirements that they have to meet, and they all qualify for this REMIC.
Right. I have a court case next week on May 13th. I wish you all could come down there.
I'd love to be down there. Try and find somebody with a movie camera that's a notary that'll come in and tape record everything. Movie record everything.
It's going to be, they're doing the same thing on these court judgments. The courts are securitizing court judgments and selling them to the Federal Reserve Bank in New York City.
So those are all REMICs too?
Yes.
Okay.
They have a security agreement, deposit agreement. This is on the website. I have the documentation on this. I have a copy of the actual deposit agreement. It's done electronically go read. You need to download Circular 7. We can go into this next week. I'll show you Circular 7 of the Federal Reserve bulletins that shows you how they do an electronic transfer under a deposit agreement. The courts are actually doing this. These attorneys are all involved in it. I put together a 15-page affidavit that goes into this whole thing.
Yeah.
And I put it into the court, and they're having a coronary over it. But you know they messed with the bull. They're going to get the horn.
Yeah.
Okay. Read this. This case is a mortgage case. It involves a house. In particular, it was a small claims action, but the courts are securitizing this. And in other words, when you go in there, you've got a conflict of interest going on because the court is securitizing the court judgment. They're getting a portion of the proceeds from the foreclosure or the forfeiture.
Okay, what do you want me to read?
Read that's 8-102 subsection 7, entitlement
7.
holder.
Entitlement holder means a person identified in the records of a securities intermediary as the person having a security entitlement against the securities intermediary if a person acquires a security entitlement by virtue of Section 501B2 or B3. That person is the entitlement holder.
Okay, I'm going to read, I want you to read this. I'm going to go over there.
Okay.
Read this.
502, assertion of
50
adverse.
No, 501. Read 501.
Put it down just so there we go. Security as an account means an account to which a financial asset is or may be.
What is a financial asset?
Anything with a security interest.
Remember what the definition of a security is?
Any interest.
No, a security is a financial asset. You read that under 8-102 subsection 9.
Any interest in it.
Yeah, that too, but the security itself is a financial asset.
Well, yeah, that's the promissory note security.
So you have a securities account with a securities intermediary that says that you have security entitlement rights and you are an entitlement holder. Okay?
Right.
That's why they don't transfer any, this is all going to come out. I'm teaching this before it comes out, before it becomes public. I'm making it public. I've got 5 claims filed already.
Okay.
For over $1 million. One is for $1,408,000.
Okay. Securities account means an account to which a financial asset is or may be credited in accordance with an agreement under which the person maintaining the account undertakes to treat the person for whom the account is maintained as entitled to exercise the rights that comprise the financial assets. Except as otherwise provided in sections D and E, a person acquires a security entitlement if a securities intermediary 1. Indicates by book entry that a financial asset has been credited to the person's securities account. 2. Receives a financial asset from the person or acquires a financial asset for the person, and in either case accepts it for credit to the person's security account. Or 3. Becomes obligated under other law, regulation, or rule to credit a financial asset to the person's security account. C. If a condition of subsection B has been met, a person has a security entitlement even though the securities intermediary does not itself hold the financial asset. D. If a securities intermediary holds a financial asset for another person and the financial asset is registered in the name of, payable to the order of, or specifically endorsed to the other person, and has not been endorsed to the securities intermediary, or in blank, the other person is treated as holding the financial asset directly rather than as having a security entitlement with respect to the financial asset. E. Issuance of a security is not establishment of a security entitlement.
So they're waiting for you to do an adverse claim.
I think so.
That's why they haven't transferred any of these.
Okay.
And why you are the person they're holding it for. They're holding it in trust. And it's a breach of fiduciary duty for them to transfer this. To transfer any of these because you are the owner. You're the registered owner.
Yeah. Okay.
And see, here's what it says. This is the taxing part of it. Are you getting an idea why you got to know taxes? See?
Yeah,
You got to know trust.
Into it.
Remember in the affidavit that attorney John Adams talked about qualified mortgage?
Yeah?
See right here?
The term
Read this.
qualified mortgage means any obligation, including any participation or certificate of beneficial ownership therein, which is a principally secured by an interest in real property and which is transferred to the REMIC on the startup day in exchange for regular or residential interests in the REMIC, is purchased by the REMIC within the 3-month period beginning the startup day if, except as provided in regulations, such purchase is pursuant to a fixed price contract in effect on the startup day or represents an increase in the principal amount under the original terms of an obligation described in clause I or II in such increase and is attributable to an advance made to the obligor pursuant to the original terms of a reverse mortgage loan or other obligation, or occurs after the startup day and is purchased by the REMIC pursuant to a fixed price contract in effect on the startup day. And number B, any qualified replacement mortgage, and C, any regular interest in another REMIC transferred to the REMIC on the startup day in exchange for regular or residual interest in the REMIC. For the purposes of subsection A, any obligation secured by stock held by a person as a tenant stockholder, as defined in Section 216 in a cooperative housing corporation, so as so defined, shall be treated as secured by an interest in real property. For purposes of subparagraph A, any obligation originated by the United States or any state or any political subdivision, agency, or instrumentality of the United States or any state shall be treated as principally secured by an interest in real property if more than 50% of such obligations which are transferred to or purchased by the REMIC are principally secured by an interest in real property determined without regard to this sentence.
Go ahead, read what a qualified replacement mortgage.
Okay, just qualified. Okay, just hold on a second. I got a little blue screen on my thing here. It's got to go away in about 10 seconds. Qualified replacement mortgage. It's still here. I can't read it. Go. It'll take just a minute for this to go away. There we go. Qualified replacement mortgage. The term qualified replacement mortgage means any obligation which would be a qualified mortgage if transferred on the startup day in exchange for regular or residual interest in the REMIC and which is received for another obligation within the 3-month period beginning the startup day or a defective obligation within the 2-year period beginning on the startup day. Do you want me to go to permitted investments?
Yes.
Permitted investments means any cash flow investment, qualified reserve asset, or foreclosure property. Cash flow investment means any investment of amounts received under qualified mortgages for a temporary period before distribution to holders of interest in the REMIC. Qualified reserve asset means any intangible property which is held for investment and as part of a qualified reserve fund. Qualified reserve fund. The term qualified reserve fund for purposes of subparagraph A means any reasonably required reserve to provide for full payment of expenses of the REMIC or amounts due on regular interest in the event of defaults on the qualified mortgages or lower than expected returns on cash flow investments, or provide a source of funds for the purchase of obligations described in clause II or III of paragraph 3A. The aggregate fair amount value of the asset held in any such reserve shall not exceed 50% of the aggregate fair market value of all assets of the REMIC on the startup day, and the amount of such reserve shall be promptly and appropriately reduced to the extent the amount held in such reserve is no longer reasonably required for purposes specified in Clause I or II of this subparagraph. Special rule. A reserve shall not be treated as a qualified reserve for any taxable year and all subsequent taxable years if more than 30% of the gross income, wait a minute, you moved it, from the assets in such fund for the taxable year is derived from the sale or other disposition of property held for less than 3 months. For purposes of the preceding sentence, gain on the disposition of a qualified reserve asset shall not be taken into account if the disposition giving rise to such gain is required to prevent default on a regular interest where the threatened default resulted from a default on one or more qualified mortgages. Foreclosure property, which would be foreclosure property under Section 856E without regard to paragraph 5 thereof, if acquired by the Real Estate Investment Trust, and B, which is acquired in connection with the default or imminent default of a qualified mortgage held by the REMIC solely for purposes of Section 860DA. The determination of whether any property is foreclosure property shall be made without regard to Section 856E4. You want me to keep going?
Didn't that affidavit by that attorney say that the loan was unsecured and that it was in default because it was never transferred?
Because it was never transferred.
Okay, so your loan was in default at closing. It was unsecured because it was never transferred to the REMIC, which is the trust.
Okay.
Neither the deed of trust or the note were transferred to the trust or the REMIC at closing. So the loan was in default. Does everybody understand that?
Let's see if we have some questions on the board again here. Where did I end up? Make the screen bigger. We can't. We'll have screenshots. Wait a minute. We'll have screenshots, guys.
Can you still see the screen now?
Yeah, I do. Oh, they want to know, Gene, where and when, Gene, some of us want to come to your court hearing.
It's going to be on, this is in California. It's going to be on April 13th.
Okay. Rob, you need a copy of the document. Email me privately. The bank just sent me a modification agreement for a car loan that I requested because my wife is on unpaid maternity leave and we cannot afford the car payment. Where I'm supposed to sign is a box with an X next to the signature. Not sure at this time how to qualify the signature. Would like to get rid of the loan and if possible without going to court, need some guidance.
Well, you can tell them to do a recoupment or set-off.
That's what needs to be done.
You need to write them a letter.
Write them a letter and tell them that you want to do a recoupment and or set-off. And let them answer you.
Under Section 1413.
Under Section 1413.
Of 111-203. Which is Title 15, Section 129A and 129C of Title 15, which is TILA, the Truth in Lending.
Okay. All right. What court in California?
It's Rancho Cucamonga Superior Court.
Rancho Cucamonga. Someone here wants to know if we're going to go over the coupons that that come with the bills on how to pay the bills. A little bit later tonight. What time do we know the court case?
It's going to be at 1:30 p.m. in the afternoon.
Okay. So what we're looking at here is what you were just saying about qualified mortgage under the REMIC. It says that the determination is done without regard to Section 856E4. Is that?
Well, what that means is, well, let's click on that. That is what defines what a real estate investment trust is. In other words, it's not a real estate investment trust.
What is not a real estate investment trust?
The REMIC, because they did. Remember what I went over last week under 856?
Yeah. What about it?
Well, it says that they have to file a tax return and take an election to qualify as a real estate investment trust. Remember?
Well, now, and that's what they're not doing, because to qualify, they have to transfer into the fund, and if they transfer into the fund, the trust, they have to do the tax return, and they're not doing that.
Yeah. So they're not qualifying as a real estate investment trust. There's D. See, this is a lengthy document. Okay, here's E, and remember it said 4?
Yes.
Here's your E4. Here's the 4. Read this.
Termination of grace period in certain cases. Any foreclosure property shall cease to be such on the first day occurring on or after the day on which the real estate investment trust acquired the property, on which a lease is entered into with respect to such property. By its terms will give rise to income which is not described in subsection C3 other than subparagraph F of such subsection, or any amount is received or accrued directly or indirectly pursuant to a lease entered into on or after such day which is not described in such subsection. Phew. Any construction takes place on such property other than completion of a building or completion of any other improvement where more than 10% of the construction of such building or other improvement was completed before the default became imminent.
Okay, why? I want to see if you guys are learning. Why is the loan in default?
Because they didn't transfer into the trust.
So the loan was in default, it was unsecured, and it was in default at closing.
Right, and it has remained in default. Because they never transferred into the trust, which created the default from minute go.
Yeah, because they never qualified as they're in possession of contraband because they haven't filed the tax return to report the income. They have to pay out 95% of their gross income in interest and dividends to the investors to qualify as a real estate investment trust. That's what this says.
Which they're not doing.
Which they're not doing. They can't file a tax return if they didn't transfer the note and the deed of trust to the REMIC at closing. And they didn't do that.
And that's what sets them up for the violation and penalties of 856.
Right. Which is $50,000 per count. Do you think this is worthy of everybody should be calling up the IRS and reporting it on a 4490 tax form, proof of claim. Write them a letter and submit the form. Say, I want you to submit a form on my behalf I'll draft the letter. I'll even do the letter for you.
Okay, and so we're going to go over that form tonight, aren't we, on exactly how to fill it out?
Yes.
Okay.
Do you understand now why it's all a tax liability and why they call it a forfeiture? They call it a foreclosure, but they call it a forfeiture on a foreclosure. The forfeiture, you're dealing with a tax.
Well, yeah, but they're saying the homeowner forfeited. In reality, the trust forfeited.
Right. Now you're starting to get it. They forfeited it.
Okay, let's go over the 4490 form.
This is why you should be doing an in-rem complaint under Supplementary Rule C.
Are we going to have a template for the students to learn from?
Okay, a template for what?
On what you were just saying, for everybody to do.
Yeah, we can do it. I can do a template, yeah.
Okay, if you give me a template, then I'll send it out and everybody can see how it's done.
Okay, do you want a template for are you talking about the forfeiture? Are you talking about the...
Well, you were just saying everybody should do some kind of a claim.
Well, everybody should do. They should send the 4490 to the IRS and have them sign it.
Yeah, but you were saying everybody should do an in-rem claim.
Yeah, that's a
complaint.
For forfeiture.
Forfeiture. Okay, that's what we're gonna need templates on. A template for students to learn.
Yeah, I can. Let me get rid of this, and I'll show you something.
So this week I'll remind you that we got to do a template.
I'll prepare a template.
Okay.
This is what you should be doing.
A Rule C, Actions in REM, Special Provisions. Complaint under 2. It must be verified. It must describe with reasonable particularity the property that is the subject of the action, and it must state that the property is within the district or will be within the district while the action is pending.
You could do an in-rem complaint against them for forfeiture. How come nobody's doing this?
I have no clue, and I'm just learning myself.
Isn't all revenue of Admiralty Maritime jurisdiction?
Well, it applies to everything that's out there.
Doesn't the Huntress case say that? That all revenue is of Admiralty Maritime law and jurisdiction? Well, isn't this tax issue a revenue issue?
Right.
And isn't revenue an in-rem proceeding? Isn't there property involved in this? Let me ask you a question. Isn't the deed of trust and the note property?
Right. It is.
Okay, so it's in-rem, and they haven't paid the tax on it, on the transfer.
Right.
They didn't file a tax return to take the election to become a qualified mortgage.
Well,
to
and
become
when
a
they
remedy.
don't, and when they don't do that, the $50,000 per item penalty that the trust has to pay to the U.S. Treasury, not to the homeowner, but to IRS and the U.S. Treasury. That's what those penalties are for $50,000.
Yeah, we're gonna do one.
Okay.
You guys give me somebody that's in foreclosure, and I'll do the complaint.
Okay. Wonderful. I've got one in mind right now that needs a little bit of help. And even after she produced, and gave notice of the 4490, the trustee's office is still with vengeance coming after her.
Well, we'll put a
We've
stop
got a
to
lot
it.
of people on the line that says, I'm in foreclosure, I'm in foreclosure. We'll have the template, folks.
Well, I'll have a template for you. I've already got a complaint.
Yeah, good,
I've already done a complaint.
good.
But this is, but see here, see what it says. What does this say? Rule G.
Forfeiture actions in REM. The rule
Okay, I want you to
governs,
read it.
this rule governs a forfeiture action in REM arising from a federal statute. To the extent that this rule does not address an issue, supplemental Rule C and E of the Federal Rules of Civil Procedure also apply. The complaint must be verified, state the grounds for subject matter jurisdiction, in REM jurisdiction over the defendant, property, and venue. Describe the property with reasonable particularity. If the property is tangible, state its location when any seizure occurred, and if different, its location when the action is filed. Identify the statute under which the forfeiture action is brought, and state sufficiently detailed facts to support a reasonable belief that the government will be able to meet its burden of proof at trial.
You could do an X-ray-L, X-relator.
Okay.
You know what an X-relator is? That means in the name of.
In the name of the people, but not having a interest yourself.
You can do it in the name of the IRS because they haven't paid the tax.
Oh, I didn't know that.
What do you think I just did? Well, how do you think I got this house I have down here in Rancho Cucamonga? I did an X-ray-L complaint against Countrywide. I've been in the house for 3 years. They've been trying to throw me out for 3 years.
They can't do it because you're taking them down with all this stuff.
Sure.
All right.
But this explains nobody uses this. This is your remedy right here.
And that's what we're learning.
This is what a forfeiture is. See what it says? Rule G is forfeiture in REM.
Okay.
I have a form book that has the actual forfeiture complaint. I'll scan the form, and I'll copy the form and then scan it into the computer, and then we'll go over it next week.
Perfect.
And you guys you can do. I want you to learn how to do all this stuff because I can't do everybody's complaint for them. So, but that's how you learn is by doing, not by somebody else doing it for you. I want you to learn how to do this.
And it
so
applies.
that you can do it.
It applies to everything, not just real property and houses.
Yeah, this applies to everything. This is all Admiralty Maritime Law. I can take you into, I'll show you I'll go into this, when we go into the form next week, I'll show you I have the forfeiture, IRS forfeiture and seizure manual. And it says right in there, they use supplementary Rule C. And you
Okay,
can
we
do a
have someone
forfeit.
here that says,
You can,
why don't you do an adverse claim on the house you're in? You just did.
I already did.
Can I do an XREL for a foreclosure over 10 years? Of course. There's no statute of limitations.
Yeah. No, not a Class 5 gift and estate tax. Another thing you can do is file a 1099 OID. Do an 8281 form. It's called Zero Your Account. See, you haven't reported this money you loaned to the lender. You're the one that loaned them the money. They never gave you anything.
Right. We loaned them the money, so we need to inform IRS that the trust is now defunct, and that's what the 4490 form is all about.
Yeah, they have a claim to the fund, a tax claim.
Okay?
You could probably sign your name as an IRS ex-relator, as an accommodation maker or accommodation party.
That's because we have a Social Security number, right?
Right. You're a government employee.
So if somebody's coming up with a motion to dismiss or to lift a stay in bankruptcy or all the other court actions that these assigned agents for the trust take into court, what would be the best thing to do if you had to answer by Friday?
Are you doing a foreclosure?
I think, yes, that's what I'm getting the impression on. There's a court action on Friday to dismiss probably an action that a mortgage or a homeowner brought against the agent. So they're going into court and getting the judges to sign all these motions to dismiss.
Yeah, I'd put in a motion to dismiss it. You could bring this up as part of your, as the grounds for the dismissal.
Dismissing their motion to dismiss.
Right.
Wouldn't that be a motion to quash?
Well, it would be a motion for summary judgment. You should file a motion for summary judgment, Rule 56.
A motion for summary judgment, Rule 56, on the premise that they're not a qualified trust, and the 91st day has gone by, the trust is no longer there, and they're not paying the taxes. And
they're not a qualified mortgage, and they're not a real estate investment trust because they haven't filed the tax return. You can write the sections down.
Right. That's what we've been going over.
That's what we've been going over.
Limitars, folks, and you'll get the areas that Gene has been talking about, and that is what you put into your summary judgment or motion to dismiss or whatever based on those violations.
You could cause these people a lot of problems. Okay, does everybody understand this?
It looks like they're understanding it.
You want to remember too that they have waived sovereign and judicial immunity. Under the Suits and Admiralty Act, which is Title 46, Section 741 through 781, or 791, they've consented to be sued.
Okay, and what was that again?
It's the Suits and Admiralty Act.
Suits and Admiralty Act. I just wanted to restate that in case some people couldn't quite write as fast as you're talking.
Okay,
so does this relate to a home that does not have a mortgage on it? In other words, a person has paid the mortgage off.
Yeah, this applies to all mortgages.
They can go back then and get the cost of that mortgage given back to them for the penalties.
Right.
Does it apply to property taxes?
It's revenue, isn't it?
That's what I said. It goes through all that. Do you have any QSIP numbers for Form 8281?
We can get them.
Okay, we have to do that. So, are not the people the warrant officers for the U.S. government?
Yeah, they're the warranted contracting officer.
Right, that's what the people are. Well, how does this apply to a criminal action?
Same thing.
It's all the
civil.
same thing.
All criminal is civil. You can actually
How would one take a template that we have on real estate and convert it to criminal?
there is no criminal. So everything
Well,
is civil.
They're what they're calling criminal. The violations are listed in 856. Even if you're up to date on all your payments, it doesn't matter.
The loan was already in default.
If you're listening, people on the line, your questions are getting redundant. We've said for 4 weeks there is no statute of limitations. I don't need to get a question on something that a house was sold a number of years ago, or you were out of the house, or it's paid. It all fits into this, and you can go back and correct everything that has been done.
See, this is the suits and admiralty. Can you see the screen?
Chapter 20, Suits and Admiralty by or against vessels or cargoes of the United States. Where's this located? This is
Title 46.
Section 741.
It's in the appendix.
In the appendix section. Okay, so let's talk about the U.S. being exempt. They have to own everything completely outright, and that's the only stuff they are exempt from suit in, right?
They've consented to be sued under the Suits and Admiralty Act.
Under what section?
Title 46, Section 741. Read it.
But where does it say they agreed to be sued? No vessels owned by the United States or by any corporation in which the United States or its representatives shall own the entire outstanding capital stock or in the possession of the United States or of such corporation or operated by or for the United States or such corporation, and no cargo owned or possessed by the United States or by such corporation shall, after March 9, 1920, in view of the provision herein made for a libel in personam, be subject to arrest or seizure by judicial process in the United States or its possessions, provided this chapter shall not apply to the Panama Canal Commission.
But they've consented to be sued under the Suits and Admiralty. This is talking about seizure.
Okay.
This is not talking about being sued.
Okay.
Here it is. Read this. Read 742.
Where am I reading? Okay. Libel in personam. In cases where if such vessel were privately owned or operated, or if such cargo were privately owned or possessed, or if a private person or property were involved, a proceeding in admiralty could be maintained any appropriate non-jury proceeding in personam may be brought against the United States or against such corporation. Such suit shall be brought in the District Court of the United States for the district in which the parties so suing or any of them reside or have their principal place of business in the United States, or in which the vessel or cargo charged with liability is found. In case the United States or such corporation shall file a libel in rem or in personam in any district, a cross-libel in personam may be filed or a set-off claimed against the United States or such corporation with the same force and effect as if the libel had been filed by a private party. Upon application of either party, the cause may, in the discretion of the court, be transferred to any other district court of the United States. Let me define that district court is lowercase.
Yeah, that's an Article 3 court.
Do we have the address of that Article 3 court and how to get at it?
Sure. I've got the address, yeah. It's in the District of Columbia.
Well, that would be something we might want to provide our listeners.
Okay. We can go into all that. But I just want to show you what some of your remedies are here. We'll go into this because this involves taxes and revenue. They're subject to all this. And they're liable for all this. Okay, here's the appendix for this.
It's under shipping?
Yeah. Here's the actual section right here.
That's what I just
you were
read.
reading.
That's what I just read.
Yeah. That's 742 of title. This is in Cornell Law. You can download this off Cornell Law. But you can do, you could.
Let me jump in here for just a minute. Under 744, release of privately owned vessel after seizure.
Okay, this deals with ESSA, but you get into, you can do an in-rem complaint, but you use 895. Remember what it said? Title 18, Section 895? They're in possession of contraband because they haven't paid the tax on it.
Okay.
See, this gets into, you're talking about criminal here now.
Okay. So it's criminal against them or criminal against us?
Well, no.
Extortionate credit transactions. There you go. Extortion and threats. They're all in there.
That's what they're doing.
Making extortionate extensions of credit. That's exactly what they're doing. That's under 892. My goodness. Isn't that what isn't that what the courts are doing too? Embezzlement and theft?
Sure. Sure it is. That's exactly what they're doing. So you can do it under this section right here, liable in rem. 742. But you can,
There's a sentence here, Section 741 appears to be repealed on the USC website. But we're not talking 741, we're talking 742.
742 is the applicable statute, yeah. But you can do a forfeiture for this, see?
Yeah.
Because it involves revenue.
So what they're doing to us, we can turn around and do to them.
Well, you know what they said about the best offense is a good defense. We need to go out on the offense and start suing these. Remember, everything is a tax liability because there's no money.
Right.
So does everybody understand? Remember what we said about the memorandum too? I don't know where I sent this out. You might want to send this out, this memorandum.
I think I have it, but I don't think you've told me to send it out. Was that the memorandum on this Alabama case?
No, this is the memorandum that says the donor may be deemed to have paid the tax by ordering the donee to pay it to the IRS. We should draft a letter. You should. They're the donee and you're the donor.
Right.
You're the holder of the power of appointment. Now, you see what I mean by the reason you guys aren't winning in court is because you're not using the proper remedy in court to get relief. You should write a letter to the donee ordering him to pay the tax. This is an IRS document. These are all IRS cases. See this case here? 88 TC, that means tax court. This is an actual 1988 tax case. I have all these cases here.
Right.
In other words, it says the donor may be deemed to have paid the tax by ordering the donee to pay it. Now, when you gave the note to the lender, aren't they the donee?
Correct.
Well, so you paid the tax. So you could file for a refund.
And that's what we do with when we file for the refund. Is that with the paid money order?
Yeah, that's what the document Zero Your Account is all about.
Right. So you would take that money order, and would that just go over that deed of trust or the mortgage and send it right back in and get the refund?
Yeah.
And then also the 4490 form would apply towards the mortgage company because they're impersonating a trust that they're not.
Yeah.
So, okay, we've got some people asking if they can have a copy of the memorandum.
Yes, we'll send that out.
Okay, this week. All right.
Yeah, here's another document I want to go over.
It's a wonderful document. Desist and refrain order. I like that one.
This is sections 25110, 25210. Now this has to do with securities. What have I been telling you people?
Right. And 25401 of the Corporation Code.
Let me. Now this is your state law. I'm going to go over this because this talks about. Read this, and let me blow it up. Can you? Is it? Let me blow it up a little
I
bit.
can read it, Gene. I can read it.
Okay.
You want me to start reading some of it?
Yeah.
At all relevant times, the TLC Investment and Trade Company, TLC America Inc., DBA, Bray Development Company, TLC Brokerage Inc., DBA, TLC Marketing, TLC Development Inc., and or TLC Real Properties, RLLP-1, hereinafter collectively referred to as TLC, issued investment instruments in the form of promissory notes.
They did what? They did what?
Issued investment instruments in the form of promissory notes.
Read that again.
Issued investment instruments. Remember, it's an investment, folks. In the form of promissory.
Isn't that what I've been trying to tell people for 15 years?
Right.
That these are investment instruments and not promissory notes?
Right. And real estate investment agreements and or investment contracts. TLC offered and sold these investments through two distinct programs.
Isn't that what they're doing with your mortgage loans?
Well, yeah, they're putting it out there to investors too. That's where they're selling them to.
Okay.
Tax lien certificates and opportunity properties. The TLC represented that the TLC investments had a one-year term, carried an interest rate between 8 and 15%, and principal would be repaid at the maturity dates. At the end of each one-year period, the investor was offered the chance to roll over the TLC investment for another one-year period.
If you go into paragraph 3 of your deed of trust, doesn't it say under payments that if there's any delinquent payments or delinquent amounts due, they can be paid at maturity?
Yes.
Isn't that what this says?
Yes. It says.
Then how could the loan be in default then?
The principal would be repaid at the maturity date.
Who's really in default on this loan?
They are the trust, because the trust is impersonating.
Why aren't you doing something about it?
Because we're just learning about it now. We could call them all impersonators.
Yeah, well, this is what wait till you read the page 2 of this document.
All right. These TLC investments were offered and sold to California's investing public by a network of sales agents recruited by TLC. TLC raised more than $156 million nationwide from more than 1,800 investors. These TLC investments were offered and or sold in this state in issuer transactions. The Department of Corporations has not issued a permit or other form of qualification authorizing any person to offer and sell these securities in this state. Beginning at the exact date that is unknown to plaintiff. Where are you going? There, stop. Nix individually became an agent of TLC, in which capacity he offered and sold securities issued by TLC to California investors.
Remember, they called promissory notes investment instruments.
Right. Nix received sales.
That's because they're securities.
Right. Received sales commissions from TLC ranging from approximately 4.5% to 6% on each dollar invested. Further, each time investors reinvested their initial investments, and some investors rolled over their investment more than once. Nix received yet another commission. Each offer by Nix and or TLC to roll over the investment is a separate offer and each completed rollover a separate sale of securities under the California Corporate Securities Laws of 1968, Corporations Code 25,000 et seq. Although Nix had some form of securities license or licenses with the National Association of Securities Dealers, he did not have the approval of any broker-dealer to sell TLC investments, and thus was not licensed by State of California or any other similar licensing entity to sell the securities at issue. The purported purpose of the offering of the securities in the tax lien certificate program was to raise funds to purchase tax liens at auction in jurisdictions that offered a favorable redemption period and redemption penalty, and either have them redeemed for a profit or obtain the property and sell it for a profit. The purported purpose of the offering of the securities of the Opportunity Properties Program was to buy distressed real estate at a low ratio of purchase price to market value, fix it up if necessary, and then sell it for a profit. In connection with these offers and sales, Nix made or caused to be made misrepresentations and or omitted material facts in connection with the offers or sales of the TLC investments, such that the sale of these securities, and you're bouncing around, the sale of these securities were offered and sold by means of untrue statements of material fact and omissions of material facts. Nix performed the little independent due diligence to confirm the veracity of these representations and or omissions, including the contents of any TLC sales brochures or the oral or written communications of TLC. Specifically, TLC and or Nix represented that or omitted to disclose to, next page, prospective investors that A, tax lien certificates were a safe, liquid, tax-deferred investment, in part because the investor held title to the property as tenants in common, and that the investor's principal was secured by real estate, while the interest was guaranteed by a promissory note. In fact, few, if any, investors were actually placed on the deeds to the properties purchased by TLC and therefore were not secured. B, tax lien certificates would pay the investors a fixed...
Read that A again.
Yeah, let's go back over A one more time. The tax lien certificates were a safe, liquid, tax-deferred investment, in part because the investor held title to the property as tenants in common, and that investor's principal was secured by the real estate, while the interest was guaranteed by a promissory note. In fact, reality, folks, reality is, if any, few, if any, investors were actually placed on the deeds to the properties purchased by TLC, and therefore they were not secured.
Do you see any of the investors' names on the deeds?
No.
Whose name is on the deed?
The TLC or the mortgage company.
No, you have a deed of trust, don't you?
Well, yeah, our name is on it.
Okay, you're an A, so you're an investor, aren't you?
You're right on that one.
Okay, why aren't you claiming the proceeds to the investment?
Well, I didn't really know anything about it till about 5 weeks ago. Or I knew, but I didn't understand because the information I'd been studying was up in the stratosphere, and I was chasing my tail around all the regulations.
How come nobody else is teaching this?
People don't know it, Gene. And even though you've talked about it and showed it to everybody for years, you've been up in the stratosphere and we've been down on Earth.
I've known this for 15 years. I've been trying to tell people for 15 years.
They're just not listening.
They're going to listen. Believe me, they're going to start listening.
What happens if a state doesn't have tax lien certificates? That's two different things, guys. These tax lien certificates are the ones from the mortgage company on the mortgage. It's not a property tax lien certificate. Right, Gene?
Yeah, I believe it is.
It is? So property tax, so it's the same as a property tax lien certificate?
Well, these were tax lien certificates were a safe liquid tax deferred investment, in part because the investors held title to, in other words, they gave tax lien certificates to the investors. But none of the investors' names were on the deeds of trust as tenants in common.
Okay. We're getting some negative comments on the question boards, guys. Stop it, or I'll find out who
So
you
in
are
other
and you're
words,
blocked.
what you're doing is they're not paying the taxes on the transfer. So what they're really doing is doing a forfeiture for the tax that they owe. They're making you pay the tax. They're not billing you for the mortgage because there never was a mortgage. What they're billing you for is the tax that they didn't pay on the transfer on the income that they're holding in this
Of the note.
of the note and the deed of trust that they never paid and never transferred to the REMIC. They're making you pay the tax, and they're doing a forfeiture on the tax.
Right.
They owe the tax, not you.
Right.
Well,
But isn't the mortgage that tax?
yes, that's the forfeiture.
Right.
That represents the amount of the tax on the investment. Remember, the note is a security, so the amount of the mortgage is the amount of the tax.
Right.
That's what they're doing the forfeiture on. They owe the tax because aren't they alleging they own it?
Well, yeah, they're impersonating the trust, and they're saying the trust owns it. And all we got to do is say, impersonator 856 says you pay $50,000 a violation, and I can count up 25 with the end of my finger right now.
All you have to do is write them a letter telling them to pay the tax. What does it say in that memorandum?
Yes.
They have to. It's the same as if you paid it.
Right. The donor can order the donee to pay the tax.
Yeah, why haven't you guys been doing that?
Guess we didn't know that that little stipulation was there.
Now, are you beginning to see why you are not winning in court?
Well, because everybody else is bringing all these other phantom arguments instead of saying the goddamn truth. Hey, Mr. Attorney over there representing the trust, would you kindly bring forth all the evidence that shows you're qualified trust and that you have paid the tax, you have filed the tax return, and that you have transferred the funds from the promissory note security into the trust? Show me the transfer. Show me the beef.
Qualified mortgage. Remember, 860G. Take note. Write this down. Title 26, Section 860G defines what a qualified mortgage is. Because the loan is not secured, it's not a qualified mortgage. That's what that attorney said in that affidavit that he filed for Horace.
Right.
Remember, Horace is a third-party beneficiary. Remember we read the order and the judge said he was a third-party
beneficiary, yes.
Okay, a beneficiary is the one that owns the proceeds in the trust. So he owns he's telling you right there what's going on. The judge is telling you, and nobody's paying attention.
The judge is saying what? State that one more time. So
the judge is telling you that that the borrower, as a third-party beneficiary, owns the proceeds that the servicing company is holding that never transferred to the REMIC.
Right. That was in the Alabama order. That's why it's such a key order.
Yes. And this was just handed down last week.
Right.
March 30th.
Okay.
Okay, finish reading this now.
Okay. The Opportunity Properties investments would provide guaranteed high returns. In fact, TLC never generated a profit, and between 98 and 2000 had lost at least $15 million. In order to make interest payments at those promised rates to investors, TLC used money from new investors, creating a classic Ponzi scheme.
Well, isn't that what these people are doing?
Yeah. He received a commission of up to 6% on every investment, as well as on every rollover of the investment. He also failed to inform investors that there were people above him who also received commissions on the sale of these investments, including Ernest F. Frank Cossey, president of TLC, and that the total commissions paid by TLC exceeded $20 million, or approximately 13% of every dollar invested. This is a very powerful order.
Remember, this is not a mortgage foreclosure case. This is the same. That's why I'm telling you, all these mortgages are investment contracts. This proves it.
Right.
Doesn't this prove my case?
It certainly does. So when these mortgage companies and these attorneys that they hire, when we do a proof of claim for internal revenue taxes, their butt's in the ringer.
Oh, you better believe it. They're going to go down. The IRS will go in there and seize everything they have. That's what you should be doing. You should be doing an in-rem complaint for forfeiture. Because they haven't, you should do we're going to do an X-ray, I'm going to prove it to you. I'm going to do an X-ray L complaint in the name of the Internal Revenue Service against these banks. I'm going to take them all down.
As long as you say all other similarly situated under the bank position, and all other similarly situated under the victim position.
Yeah.
Then we wouldn't have to go back and pay a whole bunch of money to take all this shit into court. It doesn't really need to be in court.
Right.
You want me to keep reading?
Yes.
These facts would have been material to any investor's decision to invest in TLC, but Nix did not disclose these facts to the investors. On October 5, 2000, the United States Securities and Exchange Commission obtained a restraining order against TLC and Cossey, among others. The SEC alleged that TLC was operating an illegal Ponzi scheme. The United States District Court, Central District of California, also put TLC in receivership, appointing Rob Evans as receiver. Since that time, Cossey, along with Gary Williams, Chief Financial Officer of TLC, have pled guilty in federal criminal actions instituted against them and received prison sentences based on their activities at TLC. The SEC alleged that TLC engaged in several kinds of securities fraud relating to its purported real estate business. The SEC's complaint alleged that TLC falsely represented that it was engaged in the real estate business when in fact was using investor funds to pay other investors to invest over $10 million in a fraudulent prime bank scheme, buy racehorses, make charitable contributions in the amount of $1.55 million to the high school football team that Cossey's son played for, including $1 million for repairs to the stadium, and be wired overseas. Nix did not disclose any of these facts alleged by SEC in their complaint to prospective investors. These facts would have been material to any investor's decision to invest in TLC. While so unlawfully engaged, Nick sold more than $490,000 in unlawful securities to at least 6 victims in California, for which he received sales commissions from TLC. Based upon the foregoing findings, California Corporations Commission is of the opinion that the promissory notes, real estate investment agreements, and/or investment contracts offered in either the tax lien certificate program or the opportunity properties program of TLC are securities subject to qualification under the California Corporate Securities Law of 1968 and are being or have been offered or sold without being qualified in violation of Corporations Code Section 25110.
Okay, do you know what that means to be qualified? That means they're exempt from taxation. They're exempt from being registered.
Yeah, they have to be the trust, and they have to move all the monies into the trust. They have to pay out 90% to the investors, and they have to file a tax return.
Right. They haven't done any of that.
Okay. Pursuant to Section 25532 of the Corporate Securities Law of 1968, Nix is hereby ordered to desist and refrain from the further offer or sale in the state of California of securities in the form of promissory notes, real estate investment agreements, and/or investment contracts, unless and until qualification has been made under the law. This order is necessary in the public interest for the protection of investors and consistent with the purposes, policies, and provisions of the Corporate Securities Law of 1968. In addition, based upon the foregoing, the California Corporations Commissioner is of the opinion that Nix has effected transactions in securities as a broker-dealer without having first applied for and secured from the Commissioner a certificate authorizing him to act in that capacity in violation of Section 25210 of the Corporate Securities Law of 1968. Pursuant to 25532 of the Corporate Securities Law of 68, Nix is hereby ordered to desist and refrain from effecting any transaction in or inducing or attempting to induce the purchase of sale of any security in this state unless and until he has applied for and secured from the Commissioner a certificate then in effect authorizing him to act in that capacity. This order is necessary in the public interest for the protection of investors consistent with purposes, policies, and provisions of the Corporate Securities Law of 68. Further, the Commissioner is of the opinion that the securities of TLC were offered or sold in the state by means of written or oral communications, which included an untrue statement of a material fact or omitted to state a material fact necessary in order to make the statements made in the light of the circumstances under which they were made, not misleading in violation of Section 25401 and pursuant to Section 25532. Thomas Nix is hereby ordered to desist and refrain from offering or selling or buying or offering to buy any security in the state of California, including but not limited to promissory notes, real estate investment agreements, and/or investment contracts by means of any written or oral communication which includes an untrue statement of a material fact or omits to state a material fact in order to make the statements made. In light of the some of these I'm paraphrasing, guys, because we don't need to read every tiny word. And that's just about the end of it.
Yeah, this is
So,
this. Well,
Jane,
this.
everybody is saying, can you put that in the document package for this week?
Yes.
Okay.
Yeah. You see how important this stuff is?
It gets really, really involved, and that's why we have to learn all this.
Okay, I'm going to pull all these. I have all these statutes on the
Okay, Gene, we have about 20 minutes left. We need to go over the 4490 form
Okay.
so that we know how to fill them out. What we went over the other day, like on the 5 columns.
Okay, let me find it here. I could have sworn I put that in here.
Okay, pull up the form because you have it there, and I have a blank one in front of me, and I'm sure that a lot of our other folks have a blank one after last week.
Okay, let's see. I gotta find it here.
I'm going to stop at the top of the form and go down.
Okay, let me pull it up here on the screen so you guys can.
Okay.
You notice it's got a docket number on there?
Right, but let's go on the left side so that people can understand where it says in the blank court for the blank.
This is you need to file this into your, if you got a foreclosure case going on, you
Right.
need to file this into the court.
Okay,
You put
so
your court, whatever court you're in.
whatever court you're in, and for them must be whatever county or state you're in. And then in the matter of would be the homeowner or the credit card holder or the criminal defendant, right?
Yeah, you put your taxpayers, you put your Social Security number here.
Well, okay, that's on the right side. Let's go down now. The docket number would be what?
Well, that's every case has a docket number when you're in court.
Oh, so that's the case number.
That's the case number, right?
Kind of proceeding would be
Forfeiture, foreclosure.
if it's not a foreclosure. Are they all forfeiture, foreclosure?
Yes.
Okay, every action out there, criminal, civil, whatever.
Yeah,
Okay.
they're all forfeitures.
Now, the Social Security number is a taxpayer's identification number. Is that the Social Security number with the dashes?
Yes.
And the employer identification number is without the dashes?
No, the employer identification number is the you need to submit a W-9 to the servicing company and have them fill it out. Give them get their employer identification number and put it in there.
So it's the company's EIN number.
Right.
Or the court or the county's EIN number.
Yeah, ask the court what their proof of claim for internal revenue taxes.
Okay, so
I'll bet you anything you want to bet me that I can stop a foreclosure case dead in its tracks just by filing this into the court record.
okay, so
calling up Dun and Bradstreet, getting the CUSIP number of the court. The court has a DUNS number. Get their DUNS number and get their employer identification number.
okay, so the Dunn's number, Dun and Bradstreet, you can get the Dunn's number,
Get the DUNS number,
and then you can look up their employer identification number. Wait, my cell phone's going off. Just a minute. I got to turn. Oh, excuse me. I got to turn it off. I got bells ringing everywhere. Okay, so I want everybody to understand how to go and get this employer identification number.
You got to file a W-9.
W-9 to the court, the prosecutor, the trustee of the bankruptcy court, the president of the mortgage company.
You're not making these people pay the tax they owe.
Right.
That's why you're not winning in court.
If you have a mortgage company coming after you, you ask for the W-9 form for the president of the mortgage company or for the attorney?
Okay, what is what kind of a tax is it?
Well, let's get back. I want people, this is something, I want this succinctly defined on this EIN number. Whose EIN number?
That's the servicing company, the lender.
The lender. Or if it's a criminal case, the prosecutor.
Yeah.
Or if it's a credit card company, the lender on the credit card.
If it's a criminal case, you want the court.
The court's EIN number on criminal. Okay. Okay, so then, now, under number 2, we know what number 1 is. Blank is justly and truly indebted to the United States in the amount of, with interest and penalty as shown above. So that would be the homeowner is justly and true, the lender is justly indebted and is justly and truly indebted in the amount of the mortgage or the criminal complaint or the counts of criminality that they have against you if you've been charged and convicted, all of that, right?
Right.
Okay. With interest and penalty as shown below. This debt is for taxes due under the Internal Revenue Laws of the United States as follows. Kind of tax and period.
This preempts even bankruptcy. Did you know that? You can shut a bankruptcy case down with this.
Well, that's what we're in. That's why we're talking about it tonight.
Have you read 31 USC section 3713A?
At one point I did, but I can't verbalize what it is, Gene.
Okay, I'm gonna
section.
I'm gonna reduce this down. I'm gonna pull it up.
Okay. So the kind of tax and period would be the forfeiture and we went over that 31A, 1331A. 13?
No, it wasn't 1331. It was 3713.
3713A.
13A.
Yeah, we talked about that one.
Okay, what is this? What is this? Can you see my screen?
Yes, 3713, priority of government claims. 31 USCA, subsection 3713. A1, a claim of the United States government shall be paid first when a person indebted to the government is insolvent and the debtor without enough property to pay all debts makes a voluntary assignment of property. Property of the debtor is absent, is attached, or an act of bankruptcy is committed, or the estate of a deceased debtor in the custody of the executor to administrate or administrator is not enough to pay all the debts of the debtor. Subsection does not apply to a case under Title 11, that's subsection 2. B, a representative of a person or an estate, except a trustee acting under Title 11, paying any part of a debt of the person or estate before paying a claim of the government, liable to the extent of the payment for unpaid claims of the government. Now restate that and rephrase it.
Well, that means that they have a preempt, because it's revenue that's owed to the government, it has to be paid before any other claims are paid.
So the penalties on this 4490 form have to be paid before anything else.
Before anything, before they can do a forfeiture, before they can do anything, before the servicing company gets paid. This
Well,
preempts their claim.
What about the attorneys?
What about it?
Aren't they liable on this?
Yes. That's who you're bringing a claim for.
Because they can't make the claim to the court until the amounts on the 4490 are cured.
Right.
Okay.
I'm going to show you something else.
So are any of the attorneys indebted, or is it just the servicing companies they represent?
Well, they claim to be representing the servicing company, don't they?
Right. But, you know, we need to take these attorneys down because they're the ones bringing the actions.
Okay, I want to show you something. Can you read what that says?
Proof of death to support payment. A finding of death made by an officer or employee of the United States government authorized by law to make the finding is sufficient proof of death to allow credit in the accounts of a Federal Reserve Bank or accountable official of the Department of the Treasury in a case involving the transfer, exchange, reissue, redemption, or payment of obligations of the government, including obligations guaranteed by the government for which the Secretary of the Treasury acts as transfer agent.
Let me ask you, haven't they made a presumption of death?
Well, yeah, they did when we were 7 years old, but executed it when we were 25.
No, that's what that all capital letter name is.
Right.
Well, that person's been dead from its inception.
Right.
Well, isn't that proof of death to support payment?
Run that by me and put it in kindergarten language, because I think a lot of other people are thinking what I'm thinking.
Well,
taking the proof of death and how does it apply?
Well, the all capital letter name, they made a finding or issued a presumptive death certificate because nobody's come forward as the beneficiary of the estate.
Okay.
That's how you get your prepayment. You can argue that the mortgage was paid because the all capital letter name in whose name the mortgage is in is dead. Are you getting this?
Well, yeah, the all capital letter name is dead.
Okay. Well, doesn't that say that's proof of payment?
And it has to be done by a officer or employee of the United States government.
Well, they've already done that, haven't they, under 5560?
Yeah, because they submitted your birth certificate to the Department of Agriculture when you follow the rabbit trail all the way back. Okay.
Okay, so here's
Okay, so what kind of a tax, and on this form, I want to get through this form before we go off on other.
what does this say here?
5565, 5 U.S.C., agency review. When an employee has been in missing status 12 months and no official report of his death or the circumstances of his continued absence has been received by the head of the agency concerned, he shall have the case fully reviewed. After that review and at the end of 12 months in missing status and after any later review which shall be made when warranted by information received or other circumstances, the head of the agency concerned or his designee may direct the continuance of his missing status if there is reasonable presumption the employee is alive, or to make a finding of death. When making a finding of death is made under subsection A of this section, it shall include the date death is presumed to have occurred for the purpose of ending of crediting pay and allowances and settlement of accounts. That date is the day after the day on which the 12 months in a missing status ends, or a day determined by the head of agency concerned or his designee when the missing status has been continued under subsection A of this section.
There you are.
Okay.
So they made a finding of death. So that's sufficient credit for the payment of the account, of credit to a Federal Reserve account.
Oh, so that's where they're doing the switcheroo.
Yeah.
Okay. Because we're not standing up and saying we're a beneficiary. But you know, when we stand up and say we're a beneficiary, they're walking all over that and as if you never said anything. So what are we missing here other than a judicial notice of some sort?
Appoint them as the trustee. You got to do an executor letter appointing them as a trustee.
Okay.
Filing Form 56, making them a trustee.
Okay, let's get back to this 4490 form because we're getting down to the end of the wire for this week. So under kind of tax and period, what would you put? Forfeiture?
Well, it's a capital. Well, it's a capital. What do they owe the tax on? It's the capital gains tax.
Capital gains tax, okay? The
Under
assessed balance. That would be the amount of the mortgage or the amount of the criminal charges added up or the amount of the credit card, right?
yeah.
Okay. So accrued interest, how do you figure accrued interest?
The value of the security at maturity.
Okay.
Multiply. Take your payments. Take the amount of your payments and multiply it, and well, just take the interest, whatever the percentage of the interest is.
Okay, so if you have a $340,000 house times 11.5%, don't you just multiply 11.5% to the mortgage amount divided by 11.5%, multiplied by usually 360 months?
Yeah.
Yeah.
And that would be your accrued interest.
And then yeah, that's just the interest. Now the late payment, you just go through section 865 and find all the penalties, right?
Right.
And then the total would be the
856, not 865.
Oh, 856. Okay, so then the total would be the unpaid balance plus the accrued interest plus the penalties.
And what then you put your date in there. The date the
date,
tax lien arose. That was at closing.
That's the closing date. Or
Right.
that's the date that you were convicted, or that's the date that you took out the credit card thing, or the car loan, or any other credit. The date that you did it, the very first day.
Right. These people will put track shoes on.
Okay. And then down at the bottom, you have it notarized, and you sign it. You take it into IRS and have them sign it, or if they don't sign it, you can sign it. And your title would be what? Beneficiary if you signed it?
Well, yeah, you'd be the accommodation party.
Accommodation party in the title box. The ID number would be your social security number if it's you,
Yeah.
and your telephone number and your address.
Yes.
All right, let's see if we have any few questions on this. Somebody says you can use a mortgage calculator. We could actually turn this into the attorney and the CEO of the bank.
Yes.
Where can we find the death record?
Just make the assumption. Make them prove that you're not dead.
Yeah.
What's
that's
that all
one
capital
thing.
letter name? It sure as hell isn't you.
Okay, someone says, do we use the W8BEN?
Well, yeah, you can use that, yeah.
Okay, and how about for a house that's paid off would be the servicing company of the mortgage that was paid off?
Yeah. They received the money at closing.
So like for traffic tickets, it would be the court, and it would be the date that you received the ticket.
Yeah.
Okay. For the EIN number, if you're in court, you would use the court's EIN number. If you're not in court, you'd use a bank's EIN number. You can use the state's EIN number if you want. Okay, now we have one last thing here on paying the bills with the money order paragraph, Gerard, on the back and the front. Are you going, do you want the format supplied to the students this week?
Yeah. You can
Okay.
put the format in there.
Okay, and that's about all the questions. Now, what happens if the mortgage companies are defunct and no good? Can you go directly back to Fannie Mae or Freddie Mac?
Yeah. Because most of them are HUD loans.
Yeah. Okay. So when you put down all these violations, how are they applied? Doesn't the U.S. Treasury get the violation monies at $50,000 a whack, and you get all the rest of it back?
Yeah.
And that doesn't matter whether it's a credit union or a bank or whatever they have. There's no difference. It's all the same.
Yeah, they have to pay.
The Alabama case, guys, was on the 19th or 26th webinars. If you haven't paid for those, you have to look up the Alabama case yourself. Okay, that's the end of that. We're right at 8 o'clock. I have a few notes here. Let me check one more time. Okay, would you make one of these forms for only one entity, or could you list several entities that have been violating on the Form 4490?
Well, I would make it whoever the servicing company is or the attorneys.
One form per company instead of one form for several companies.
Yeah, you could.
Okay, now let me bring this back a little bit better. Some of these mortgages have been sold 5, 10, 15 times. Would you list each and every one of the companies that touch the fruit of the poison tree, so to speak, on one form, or would each company get their own separate form?
Well, you could list them all under there, or you could list the one that's making the claim.
On any one given mortgage, like the research that I've done when we were researching mortgage companies and trying to get a handle on this, we researched, and some of the companies that we researched went all the way back to the beginning. There was like 10, 15, 20, 25 companies that this original loan, the liability of the company, who was an assignee of a previous company, of the previous company, of the previous company, we went all the way back to 1860. Do we go all the way back to those beginning companies that created the company that went into default, or do we just do the company that went into default on closing day?
I would use the original servicing company because they were the ones that were in default at closing.
Right, but if they're no longer in existence, who do you go against? Like my mortgage, one of my mortgage companies filed bankruptcy, and they said I didn't make a claim for these particular properties while they were in bankruptcy, so I was SOL. And I'm saying, sorry, you took over the assets of this company that went into bankruptcy. There's no statute of limitations on your violations. So if you took on the assignment of mortgage company A and they went bankrupt and you took all their assets and you're now mortgage company D is still liable, right?
Yeah.
Okay.
The original, because they were in default at closing, the original servicing company, whoever's claiming to be the lender, is the party that's liable.
Right. Well, that's the company that went into bankruptcy a few years after they lifted the property from me.
Well, whoever's claiming it, but who ultimately foreclosed on you?
That was that company that foreclosed on me, but I've been out of the property for 6 years.
Okay, but who foreclosed on you?
The company was New Century, and they revamped their company and made a new company. But they're saying the original company is not liable because they went bankrupt.
Okay, go do the
4490.
Do the 4490 on the new company.
Right, that's what I'm trying to say. Okay, now what about people that have had their homes repurchased by another individual? Can you give notice to that other individual that they've got so many 72 hours to vacate your property or they're liable for the taxes?
Sure.
That's what I thought. Man, I got 7 properties and 4 cars. Boy, am I going to go to town. Okay, Gene, we're at the bewitching hour of 2 hours. If you're going into one more thing here on authorized signature for the next 2 minutes, and then we will say goodnight to our people. But I want to tell everybody, most of you, all of you, did not make your payments until this morning. Don't do this to me. You'll find yourself not approved for the webinar because I couldn't do all of the clerking to get you approved for the webinar. So I would suggest that you start making your payments and getting registered on Tuesday, Wednesday, Thursday, and Friday. Not wait until Saturday because I'm not going to be pushed between 4 and 5 o'clock in the afternoon for 35 members that want to register late and pay late. You'll have to wait for the recorded webinar if you do that. So I would suggest this week to go do that. Usually I try to have if you make your payments by Wednesday, Thursday I get the link and everybody can register Thursday and Friday. So be kind to Maria, please. What are you bringing up, Gene?
I'm just copying these.
Okay.
We'll go over these next week.
Next week, and this week, guys, expect a screenshot file and expect some more template files from Gene. With that, Gene and I both say, and I say truly from my heart, thank you, everybody, for attending. We're so excited to bring this information forward and to really make it applicable so everybody can understand the applicability of these forms, how they are to be used, and to whom they are to be presented or tendered to get you guys out of the soup. Okay? Gene, do you have any last words?
Yeah, I love you all. Come back next week. But get signed up early. Get your payments into, you've got my email address. You got to make it payable to manowskitom@yahoo.com.
most of the people also, Jean, that I'm sending out the information letter to, look at the top of the letter in the blue links. They are all dated, and they tell you the webinar links from the very first one on March 5th to today's, and next week's will be on there because I'm just adding them every week. So make sure you look at the top of the form to see how to get into the registration page of webinar.com. This week we are changing companies. I have found a better company, and I should have that all completed by tomorrow so that you'll get the necessary links and the necessary information, because the information letter will be amended for the new company. It has a better platform, and it costs 1/5 of what this company charges per month for servicing. So I'm still checking out the recording. I'm still checking out how to do all this. We will have it ready. And I will say thank you very much, and I'm so grateful for each and every one of you. I'm going to stop the recording now. Thank you, and we'll see you next week.